Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. There has been a new document that dropped on the docket. It is called Notice of Intent to Use IRE 404B Evidence. I is Idaho Rule of Evidence. And this is filed by the Latah County Prosecutor's Office. It says here, comes now, the state of Idaho, by and through Ashley S. Jennings, Latah County Senior Deputy Prosecutor, and hereby gives notice, pursuant to Idaho Rule of Evidence 404B2. The state of Idaho intends to present evidence of crimes, wrongs, or other acts specifically. And the first bulleted item, this is at the bottom of page 1, video of traffic stop occurring at West Pullman Road, Farm Road in Moscow, Idaho on August 21st, 2022. Involving Brian Kohberger and Latah County Sheriff's Office Corporal David Duke. And then it gives an AV number here discovered on or as. Going on to the next page, and it states here, citation, and the citation number is provided here. Issued regarding same traffic stop. This is the same traffic stop we just read from on page 1 involving Deputy Duke. Discovered as Bates, and it gives a Bates number. Bates numbers are typically stamped at the bottom of discovery. Be a Bates number 0001, might be the first page of the first piece of discovery that, let's just say, a state might mark and then produce to the other side in response to a first request for production of documents. So that's what Bates is. And it's really helpful because if you can just imagine, we've heard that there is a virtual mountain of evidence, gigabytes, terabytes that have been turned over. And just imagine if you're in trial or at a hearing and you need to refer to a document that was turned over in discovery, you might do something like, well, Judge, state will now refer to Bates number 0001, produced in discovery on such and such a date to the defense, rather than going through the rigmarole of going through a large pile of paper and trying to get everybody on the same page. If state intends to introduce this evidence for the purpose of proving defendant's identity, vehicle, address, and phone number, this issue has been previously addressed by the court December 15th, 2023. This would have been back when the matter was proceeding in Latah County before the Honorable Judge John Judge, prior to change of venue the following September 2024 to Ada County. So this was previously addressed by the court, that would have been Judge John Judge, December 15th, 2023, quote, sealed order denying motion to dismiss indictment on grounds of biased grand jury, inadmissible evidence, lack of sufficient evidence, and prosecutorial misconduct. See page 43. This document is completely under seal. And this was back when Mr. Kohberger was trying to set aside the indictment on the grounds that are stated here. So it appears that this evidence now that the prosecutor has to give notice, and I'm going to go to the rule in just a second and explain why, was previously introduced by Judge John Judge for another purpose. Respectfully submitted, all caps, this 4th day of February 2025, hand signed Ashley Jennings, senior prosecuting attorney in the Idaho versus Kohberger matter. If you would like to see this document, please go to the Idaho cases of judicial interest. You want to scroll down past a few cases to Idaho versus Kohberger and then continue scrolling for a while. The documents begin with the affidavit of Detective Brett Payne, the PCA probable cause affidavit, December 29th, 2022. So you have to go down to February 4th, 2025 to see this document. Now, what is this rule of evidence? Usually you can't introduce evidence in, and there will be motions in limine that both sides will be introducing very shortly. It was due February 10th to be filed simultaneously, meaning both sides would be submitting these motions in limine where they would look to keep certain information, certain documents from the jury's ears and eyes so that the jury never knows that it's even present or that it exists. And what the parties might do would be to get rid of some extraordinary prejudice. It might be way too prejudicial to the defense. The defense might look to seek to keep some information out. Same with, let's just say there's a victim of criminal conduct and there's some information about the victim that would be way too prejudicial for a jury to hear. Motion in limine done by, let's just say, the state to keep that information out. But it says here, this rule, there are times when information regarding a crime, for example, may be used. And we just read the reason why Ms. Jennings is saying that the state of Idaho will be relying on this documentation. The rule itself, if we go to B2, says permitted uses. Notice in a criminal case, this evidence may be admissible for another purpose, not to show bad acts or that somebody has a propensity of doing something. It may be admissible for another reason, another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, which is what it appears Ms. Jennings has selected from this group, absence of mistake or a lack of an accident. And in a criminal case, the prosecutor must file and serve reasonable notice of the general nature. So that's what Ms. Jennings is doing here. You saw in her filing that it says she's giving notice. She is doing what she's required to do under this rule. If you would like to review this document, please again go to the link that I have provided in the description to this IndyZone presentation. Please read it for yourself. And if there are any comments, any questions, please let me know. All of your feedback, comments, thoughts are invaluable. And if you like our content, please do subscribe to the channel. This is Kathy. Thank you for joining us here today.